We're moving right along to Representative Edwards' Bill 5265 and 5266. Representative Edwards, the floor is yours. And I hope you heard it and you're not out in the backyard shoveling some snow.
I'm here, Madam Chair. Sorry, I was doing the Zoom thing. I was double doing work. So, in the interest of time, Madam Chair, I have two bills before this committee. I have the same witness on both of them, Richard Sinapi. If you would entertain my request, I would have him talk on both bills, and that will be pretty much the rest of my testimony.
Okay, just know that you have a little demerit coming.
I have demerit, ma'am. I'm the one you were afraid. I wasn't even on your committee last time. So, Madam Chair, I defer to you.
Okay. Thank you. Mr. Sinapi?
Last time. So, Madam Chair.
Mr. Sinapi, you are on your time on 5265 and 5266. Representative Edwards' bill. The floor is yours.
All right. Can everybody hear me okay?
You can bring it down a notch, though. Yes, we can.
Oh, all right. It's actually too loud. Okay. So I'd like to speak on behalf of 5266 first.
Okay.
Which is very similar to Rep. Wilkinson's bill 5262. Our bill is...
So then you're only going to present what the difference are not, opposed to going...
Correct.
Okay, thank you.
Correct. And just reinforce a couple things that Michael Avor had said. Anyways, on 5262, one problem with 5266 is, by the way, I want to get it out of the way. Section 2 is wrong. It says shall apply retroactively. That would be the sub A. But anyways, the bill itself, 5266, is limited, and all it does is it seeks to restore the rights of employees to seek relief against individual employees for discrimination in the workplace. It does not have, it's not as broad in its coverage. I support, obviously, Rep. Wilkinson's bill, and I would prefer that if you would pass that. But if there's any reluctance to expand the scope at all, I would ask that you consider this bill, 5266, which just restores rights that Michael Avor has already testified to, were existing in Rhode Island for over 30 years before the Mancini decision, which I agree with him, was wrongfully decided. Because it disregarded the express language of the statute, which says, no person shall. No person shall means everybody, not just employers. In any event, and on two other points, as Michael Avor said, it is a pro-employer. Why? Because it is a deterrent to coworkers engaging in discriminatory conduct if they know they can be held personally liable. If they're not, they get a freebie. They get away with it. With respect to employees, obviously it's a protection to employees because by deterring coworkers, it protects employees and provides them a remedy should coworkers engage in discrimination. In answer to Rep. Claude Vasey, asked for a couple examples how restoring individual liability might expand the protections in a specific case. I can give you two cases. One is a coworker. Young woman, very diminutive, quiet, first job perhaps, very young. And there's an older coworker who engages in unwanted sexual discussion. He hits on her. He makes advances on her, touches her inappropriately. she is reluctant to do anything. She finally goes to the employer. The employer gets involved. The employer says, stop it or you're fired. Maybe even suspends the guy for a week. Who knows? The person comes back again. Says, "Oh well, don't say anything because I'll get fired," and again engages in that type of conduct. The young woman is, mortified. Has to take a leave of absence. Complains to the employer again. The employer then takes action to fire the person. At that point, she has no claim against anybody under existing law. Why? Because under the Farragut doctrine, the employer gets a pass. If the employer does not know of discrimination, it cannot be held liable unless it is a management employee, somebody who could take tangible job action. So in this case, the employer took action. They suspended the person. Okay. And then they came back again, did it again. The employer fired them. The employer did everything right. That employee has no action against anybody under current law due to the Mancini decision. This would put liability on that coworker, and it would also deter coworkers from engaging in that conduct. I'll give you one other brief example.
Can I interrupt?
Absolutely.
Well, the chairman has to tell me if I can interrupt.
Chairwoman, darling.
Chairwoman, excuse me.
Representative Claude Vasey.
Thank you, Chairwoman. Mr. Sinapi, how are you?
Good, Matt.
So let me ask you a question, Richard. In the scenario you just stated, if this bill were to become law, the young woman would have recourse against the individual who directly harassed her, correct?
That is correct.
Would she be able to also direct legal action against the employer?
I believe the employer may raise the Farragut defense that it took appropriate action once it was aware of the offending conduct. And yes, they have a defense which would be complete immunity from any responsibility.
But you said may, opposed to...
May what?
You said the employer may be able to, opposed to can.
The employer has a right to raise that as a complete defense to any liability. Absolutely. They can. And they will if they have a competent attorney.
Okay, thank you, Richard.
Thank you. Proceed with your
Let me
other
give you another
example.
Yeah, another example. Here's another example. Again, the same employee, and I don't mean to be gender, we could be gender neutral, I guess. It doesn't really matter. But the same employee, a young employee, a receptionist, and the FedEx man comes in every day. FedEx man, same exact type of conduct as the coworker example I gave. The person finally complains to the employer. At first doesn't because, they're reluctant to do so. They don't know if it's appropriate, but they complain to the employer. The employer then has no control over the FedEx worker, but the employer will then contact probably FedEx, the FedEx management. FedEx management hopefully will take appropriate action. They may or may not. In any event, whatever they do to this person continues this conduct. Again, she complains to her employer, the FedEx, and again, this woman has been devastated now by this guy's conduct every day without relief. Complains to the employer, her employer. The employer calls FedEx and says, I don't want this person on the property again. If he comes, we'll have escorted out by the police. At that point, you think FedEx is not going to send the person. So now it's stopped, but it's just like the other example I gave. The conduct has stopped. Her employer, who's the only one that can be liable under current law due to the Mancini decision, did everything right. They talked to FedEx right away. They took appropriate action to stop this from happening right away. The person didn't correct their conduct. They then called and said, I don't want them on the property again. You can't sue her employer. They did everything right. You can't sue FedEx because FedEx is not her employer. So who are you left to go after? No one. Those are two good examples of how this would close the gap and provide relief and a remedy in those situations left open due to the Mancini decision. I'd be happy to answer any questions.
Are there any questions? Hearing none, that would conclude the hearing on 5265 and 5266, Representative Edwards' bill. Thank you, Mr. Sinapi.